Mr. Mataboge, we were on the investigation of the breach of the ethics code in respect of the benefit of a judge. You indicated you were involved in that investigation and it was closed as unsubstantiated, correct?
That is correct, Advocate Bauer.
Right. Then there was a further complaint, which I think comes from a member of the public. I'm trying to refrain mentioning people's names, but the investigation related to what was termed by the complainant to be market influences which drove the former president to remove the then finance minister Van Rooyen and replace him with Minister Gordhan. Were you involved in that investigation?
No, I wasn't involved in that one.
Do you know what the outcome was?
No, I don't remember.
Okay. Then the other one I have is also looks like it was a member of the public where they alleged, amongst others, corruption, irregular procurement processes, violation of the PFMA, nepotism, and racial application of the disciplinary code since 2008. Would that be the BB&D one?
No, the BB&D one related to the modernization program only.
Okay.
It wouldn't be that one, and I don't know which one is that. I was not involved.
You were not involved. Do you know if that one is completed?
No, I wouldn't know. No.
Okay. And then the other one that I have is obviously the one relating to the Pillay pensions case where the investigation wasn't directed at Minister Gordhan specifically. Am I correct?
Yes, correct.
Right. Are you aware of any other investigations?
No, these are the only ones that I'm aware of that fell within my purview.
Okay. Right. Now, as the chief investigator, you would also be aware that all the investigators and the executive managers are meant to have top security clearance, correct?
Correct, with power.
You also, if I recall, you deal with quite a few of the important matters, and you mentioned to us that since you've taken over as chief investigator, dealing with some of the high-profile cases, the leaks in respect of these investigations had, I think, become something of the past. Would that be a correct characterization?
That's what I said, and that was the observation I made. Yes.
Do you wish to add anything to that?
Yes, I would, except to say that it was because of what the PPs are trying to deal with the situation of leaks by having as few people involved in the crucial and sensitive and investigation that involved especially the executive authority. The lesser people you had, the more you could hold them to account. And maybe that helped in my view, if I may express an opinion here, with Bauer. Thank you.
Right. But that also had the effect as chief investigator, Mr. Mataboge, approximately how many files do you carry that you have to oversee at the GGI?
It became quite a number, I must admit.
Okay. And in some of those, you would be part of the command chain to which you would account to the executive manager and the CEO, correct?
That is correct.
And then in others, as chief investigator, because of the PP's measures, you would be accounting directly to the public protector.
That is correct. That those that should, like Osasa, allocate to me to deal with particularly. Thank you.
Right. So would that be Busasa? Would that be the SARS unit one as well?
Yes, the SARS unit one as well, but that was first handled by other people before it came to me. before I could be appointed the chief investigator. It was handled by some other team members. Yes.
And after it came to you, did you report to anybody else or did you report to the PP?
The reporting channels were still the same. People would, from time to time, sometimes want me to report directly or come directly to have a meeting with them, but the reporting channels were still there. Even memos that were being submitted would go through the CEO, not the CEO, the COO, as well as the executive manager before they reach the public protector.
So if you submitted the section 7.9 or the report, would you have submitted it to the EM and the CO in the normal chain, or would you submit it directly to the PP?
No, it would go through the EM and the COO, and it will go to the PP.
By the way, in any of the investigations that had been conducted, that you had been involved in respect of Minister substantiated or they'd been reviewed and set aside by a court, am I correct?
Can you repeat the question? I would power.
In respect
Don't
of,
get it.
in respect of any of the investigations that had been conducted, in respect of which you had been involved in, involving Minister Gordhan, they had either been unsubstantiated or they had been reviewed and set aside by a court. Would that be correct?
Chairperson?
Not all of them, I think.
Okay, Advocate Mpofu.
Yes, okay, well, I think the witnesses
Yes,
come to the
responded.
rescue
Yeah, thank you.
of Advocate Bauer, because earlier she had herself had elicited an answer that there's an investigation that's still even in the pipeline. But anyway, I think the witnesses resolved it. Thanks. Thank you, Chair.
Thank you. Advocate Bauer.
Chair, I don't know what answers the witness is going to give because I hadn't at length consulted with this witness. Mr. Mataboge, I probably phrased the question wrong. I'm talking about the investigations that have been completed, not the ones that are still in the pipeline. Of the ones that have been completed, right, they've either been unsubstantiated or they've been reviewed and set aside by the court. Are there any which have not been, that fall into any of those two categories? I think you're muted.
I'll have to check.
Sorry, we didn't hear you. You were muted.
I'm saying that then I'll have to check on my records because what you're saying is one in the specific ones that were set aside and those that were not substantiated versus those that went through or that were successful. I'll have to check my records if you may indulge me on that one.
Not a problem, Mr. Mataboge. I accept that we wouldn't have consulted or prepared for the questions I'm asking. So if with leave of the chair, we could maybe have a running list of stuff that you're not able to answer. And when you do come back the next day, we could maybe then just pick up those questions if you then have an opportunity to check on them. Would that work, Mr. Mataboge?
Yes, I can check them, Power.
Okay, just. Now, in the greater scheme of things, investigators, and I thought you were saying this to us in your opening address, you are the foot soldiers of the PPSA, and that ultimately the reports are signed off by the public protector. Is that a correct understanding?
Yes, that is correct, Power.
Right, and effectively the direction and the contents of the report are determined by the public protector.
Not really, because as an investigator, we've got to direct the investigations and then the public protector to then advise us and guide the investigations to their conclusions. It doesn't mean all the directions are coming from her.
But would it be fair to say, and I think I saw it written somewhere that you've characterized it that she is diligently involved in investigations of matters from the start to the end? Would that be correct?
That is correct, because when we submitted, for instance, where the Executive Members Ethics Act is involved, we have to submit the investigation plan to her. We have to submit the document request letters through the normal channels through to her. So in such instances, she'll be involved up to the end of an investigation.
And she would provide continuous inputs to direct the course of the investigation throughout it.
Yes, correct.
And she would assist you in providing case law or other conclusions and debate issues with you while you're busy with the investigation.
Very much so, Advocate Power.
And do you find that you're able to persuade her to a different viewpoint, to a different conclusion, to one she may be inclined to reach? Or is there or are you not able to?
On more than one occasion, we managed to do that.
Okay.
As a team, not even myself in particular, because when we submit to her, we submit with the interpretation and application of the law to the facts, and we motivate to her, and we sit and debate, and we are able to persuade her on a number of occasions, yes.
And you're not the first one that says that to us, but others have also said that there are times when she's determined that that is the correct path to follow. She makes the decision, and that's the direction that the PPSA takes. Would that be correct as well?
That would be correct as well, because at the end of the day, she's the one who appends the signature, if I may say. And the appending of the signature should obviously be with her being satisfied with what she signs for.
And there is nothing wrong with that, Mr. Mataboge. You're correct in pointing out she signs off on it, and she must be satisfied with the contents of the report. Is that how I understand what you're saying?
That is correct, and if I may substantiate that, then I'm going to be going back to what I had put earlier on to say, you know, where I'm coming, even in the past era of the previous PP, you'd be told that the PP is the one that the report is the PP's report, it's not your report. And we were normal, I mean, we were accepting that as normal to say, at the end of the day, the final word comes from the PP as the signatory.
Okay. Now, I want to test, I mean, you two are a lawyer, Mr. Mataboge, correct?
Yes, correct.
And in fact, most of the investigators, if not all of the investigators at the Public Protector's Office are lawyers to different degrees.
Yes.
Some may have practiced, some may not, correct?
Yes.
All right. Now, as a basic proposition of law, would you agree that the jurisdictional facts to bring a law into force must have been complied with before it has legal efficacy? In other words, if it's legislation, it must have been adopted by Parliament and it must have been signed by the President before it has a force of law.
Yes, it is correct.
And in a similar way, if it's something that comes out of a local authority, it must have gone through the municipal council, fulfill the jurisdictional facts before it's accepted as a legal instrument emanating and binding on the local authority. Would you agree with that?
Yes, I do.
And regulations must be gazetted. They must be signed off by the relevant authority before they become force and effect as well.
Correct, yes, Advocate Power.
And you would also be aware, I think you referred to it as high-profile matters and others refer to it as political matters. They are matters of utmost importance to the country. Would you agree?
Yes, I agree, but not all of them, they are political matters. High profile for us as an institution would mean even complex, we call them conduct failure, complex relating to tender irregularities and so forth, not necessarily political matters.
Okay. So there's a distinction between political matters and high-profile matters. Some may be both and some may not.
It's correct, Bao.
Right. And some of the EMEA complaints involve members of the executive in the National Assembly. It would also involve members of the parliament. Would you agree with that?
Yeah, yes, I agree.
And in a number of these cases, if not all, they have very serious consequences for not only the subject matter of the investigation, but also to the country. Because
Yes,
it's
I
an
agree.
elected, you'd agree with that?
Yes.
Right? And so when very serious findings are made by the Public Protector's Office, it has an impact on public confidence in our elected officials in some way or another. Would you agree with that?
Yes, I do.
And this is, in some ways, makes the Public Protector's Office a very important cog in our democracy because of the wide ambit of her powers and because her remedies have binding effect. You agree with that?
Correct. I agree. Bao.
And that places a huge responsibility on the Public Protector because those reports become very important once they're issued. In other words, you would expect that the preceding process would have been meticulous, thorough, reflect a high level of competence. Would you agree with that?
Chairperson?
Just pause, Advocate Bauer. Advocate Mbofu?
Yeah, I must object strongly to this. I don't know. It looks like Advocate Bauer is giving evidence now, and she just expects the witness to say yes, yes, yes. So I don't know who's giving the evidence, and the witness is just being used as a prop to say yes to Advocate Bauer's evidence. So unless if whatever she's putting comes from some source, and she must enlighten us what that source is. If it doesn't have a source, then the source is her, and that's not allowed.
Thank you, Advocate Mbofu. Advocate Bauer?
At any stage, Mr. Mataboge can say no, he can elaborate, he can disagree. I'm not using him as a prop to say yes. I'm sourcing and understanding what the importance is of the reports on which has been worked with. Now, I'm not for a moment giving evidence, and Mr. Mataboge must be free to disagree with me. I said that to him up front. He can elaborate on it in any way.
Yeah, Chairperson.
Yes, Advocate Mbofu.
Yes, no, that's exactly the problem I'm complaining about. Mr. Mataboge is not here to agree or disagree with Advocate Bauer, as she says, that he's free to disagree with her. She has no role in this except to be an evidence leader. So Mr. Mataboge or any other witness is not here to agree or disagree with her. She's nothing to this commission. She's just a legal practitioner like me. And when I put propositions to witnesses, it's because I'm putting them because my client has put them to me, but I'm equally irrelevant to these proceedings otherwise. So no witness is there to agree or disagree with Advocate Bauer or me, because we have nothing to do with this. Thank you.
Thank you, Advocate Mbofu. Let me note your objection, and then I will travel the journey with Advocate Bauer and see where I need to intervene.
But Chairperson, can I just say something? I'm sorry, I don't want to waste your time. I don't understand your remarks. When I'm asking for a ruling on an issue, and you tell me you're traveling a journey or going with the flow, or those kinds of indistinct remarks. Yeah. So what does that mean when we're traveling the journey? Does that mean she can continue asking the witness to agree or disagree with her, or does it mean she cannot?
Thank you, Advocate Mpofu. I said I have noted your objection, and I'm asking Advocate Bauer to interact with the witness further. I will be watching if there's anything untoward in terms of what she's doing. Go ahead, Advocate Bauer.
I'm not going to get into a debate with Mr. Mataboge. The proposition I would put to you, or I had put to you, given the importance of the reports issued, of the nature we were discussing, it's not unreasonable that when these reports are published, that the preceding process is meticulous, that there's a high level of thoroughness and competence in those reports. Would you agree with that?
Yes, I agree to that. I could even take it further to say, and that's all that we do by all sincerity, and the PP also does that with us. Maybe as it were, in the eyes of the review judges, we fall short somewhere, but we do our best in the circumstances. Thank you.
That's fair comment. Can we also say that underscoring what you do, you endeavor to be fair, and that fairness must be must extend to both to the complainant, to the witnesses, and to those who are implicated in your reports. That underlies the work that you do. Correct?
Yes. That's exactly.
And so there must be no taint on the report that there's been any predetermination of any outcome. You wouldn't, as a chief investigator, want that perception to be created correctly or wrongly. Would you agree with that?
I don't know how to answer, but in all sincerity, we do our best. We work without fear, favor, or prejudice, and I wouldn't take it any other way except to say that we do our best as PPSA, notwithstanding the comebacks, as I call them, the comebacks.
Mr. Mataboge, can I take you to the SARS report? I'm going to ask Shepard to put it on the screen. It's in file E, bundle E, item 4, page 216.
Yeah, page 216. It's PG1.
It's PG1.
No, it's a PDF. It's a PPSA.
It's PG1.
It's PG1, annex to PG1. Page 216.
216 of the PDFs, if you just click on 216. 4. Go to that paragraph so you can tell her what page 5 and 15.
No. Go to item 7. Bundle E, item 7. And then in item 7.
Go to item 4.
To see. And then there go to page 216. Yeah.
Okay, so we
Paragraph
5.8.15, which one sees on, I'm going to talk before we get there because you would be 5.8.15. It is the statement that one finds in almost all of the reports that I've come across. Mr. Mataboge, you would be very familiar with it. So whilst they're finding the page, it's the paragraph that says the public protector is not a passive adjudicator between citizens and the state, relying upon evidence that is placed before him or her before acting. His or her mandate is an investigatory one requiring pro-action in appropriate circumstances. Although the public protector may act upon complaints that are made, he or she may also take the initiative to commence an inquiry and no more information that has come to his or her knowledge of maladministration malfeasance, or impropriety in public life. You familiar with that, Mr. Mataboge?
Yes, I'm familiar. It comes from the maid and guardian judgment, I think.
5.8.1.5, right?
Yeah, page 300.
Yeah, maybe let's wait for it and see all of us.
And I want to paraphrase that into a simpler English, and you tell me whether that is how it's understood as well. It means that the public protector doesn't only